For the foregoing reasons, the court grants the motion and stays the rule in its entirety. Nationwide pistol brace injunction granted by the Northern District Court of Texas in the case of Britto versus ATF, linked in the description box below, is the order. Boom. How did we get here? What the heck happened? Now that you have the headline up front, let me break this down as quickly and as succinctly as I possibly can. We're talking about predominantly two different things. One is the Administrative Procedures Act, otherwise known as the APA. And like many of you, you probably didn't even know this thing existed really until pistol braces or maybe a few other issues if you're a Second Amendment nerd. The second thing we're talking about, though, is way more exciting than the first. So much more exciting. So stick around because you're going to like this. All right. So we're talking about a preliminary injunction that came out of this case, Britto versus ATF, issued today, November 8th, hour and change ago. I only know about it because I happen to be friends with somebody who I've interviewed on this channel before. You can see the attorney who got this injunction if you scroll through my interview playlist, Lucas Weber with the fantastic Wisconsin Institute for Law and Liberty, Britto versus ATF. Let's start with the APA, then we're going to be moving and talking about the more interesting thing, at least interesting thing to me. We're going to try to cover this as quickly as I can. All right, so the APA, the Administrative Procedures Act. Quick, brief summary. If this is the first time you're waking up and you're like, what's the APA? It's not APA, it's the APA, the Administrative Procedures Act. So recall that, of course, Congress, the legislature, federally speaking, passes laws. But when they pass laws, they can't foresee every single application of these laws. And basically, that can be a mess. So what the executive branch has done is they have basically delegated certain powers, certain executive powers to different agencies. Recall that there's about 438 federal agencies as well as sub-agencies, the Internal Revenue Service, Food and Drug Administration, the ATF, all these different groups, the Environmental Protection Agency. It is their job, whether we like it or not the subject of this video, but it's their job to basically go out and try to interpret these rules, these laws without overstepping the boundaries of these laws to try to fill in any interpretive gaps that might be out there. So as long as basically what they do is reasonable, they're not transgressing any lines, they can do that. That's part of their purpose. In order to do that, they have to pass notice of proposed rules where they draft these proposed rules, like, for instance, the pistol brace rule. And then they're allowed to make some changes subject to public comment and other kind of pushback and feedback. However, the final rule must be a logical outgrowth from the original proposed rule. Okay. So the Fifth Circuit, in another fantastic case brought by the Firearms Policy Coalition, another great group, go ahead, check them out. Also plug Gun Owners of America while we're talking, although there's lots of others to join as well. The judge in that case that we'll be getting to basically said, look, this is not a logical outgrowth. If you look at the notice of proposed rulemaking for the pistol brace rule, we're talking about basically a very hyper complex and technical point scoring system whereby you have to figure out whether or not your pistol winds up becoming an SBR, short-barreled rifle, which is illegal without the proper paperwork and sign-offs and so forth, thanks to the National Firearms Act and the Gun Control Act of 1934 and 1968, respectively. So the Fifth Circuit swooped in and said the rule was not a logical outgrowth of the proposed rule, and, quote, the monumental error was prejudicial, end quote, and, quote, it must be set aside as unlawful, end quote. That's from Mock v. Garland. That's old news. The reason why it's relevant here is because the judge in this case basically adopted by reference and said, yep, the Fifth Circuit said this, that's good with me. And you know what? That's all fine. But keep in mind, that's not all the Fifth Circuit did. What they did in that case, Mock v. Garland, is they then remanded it from the Fifth Circuit Court of Appeals down to the federal trial court and basically said, trial court, take a look at any other criteria that you believe may be relevant when it comes to enjoining this rule. Okay, so in other words, when it comes to some sort of injunction. And that's what they did in that case. And the judge in this case felt like, you know what? I want in on this action. And that's exactly what he did. Because on remand, the court did that and further found, now we're getting into the second issue, that not only did the rule fail the logical outgrowth test, but it also dove into issues of common use. Yes, Seventh Circuit Court of Appeals, hopefully you're paying attention to this. I'll give you some citations if you get confused in your next so-called assault weapons ban case. Cover that in our video the other day. So the ATF's regulatory analysis basically concluded that there are between 3 million and 7 million, with a 50th percentile estimate of 5 million pistol-braced pistols under ownership of the law-abiding individuals for lawful purposes throughout the United States. In the final rule publication as well, the ATF did not dispute the noteworthy public comments pointing out that there are millions of pistol brace owners and pistol braces that are in common use across the United States. Now enter a 2016 U.S. Supreme Court decision called the Caetano decision. For those of you on your lawnmowers, that's spelled Caetano. This U.S. Supreme Court decision now basically rears its head because Caetano found that, look, stun guns are in common use based on in their estimation, hundreds of thousands of tasers and stun guns that have been sold to private citizens. Here we have hundreds of thousands versus upwards of 7 million per the Congressional Research Service. I'll also throw in there as well, by the way, Justice Thomas noted in a dissent on a case where the Supreme Court did not take a case, but Justice Thomas dissented from the Supreme Court's decision where they denied the writ for certiorari. He noted that semi-automatic rifles are in common use, saying, quote, roughly 5 million Americans that own AR-15 style semi-automatic rifles out there, end quote. Now, we know that that number now today is closer to 20 million, 22 million, possibly even higher. And I also will note, in case you're like, but Tom, that's a dissent from a denial of certiorari. That's of no precedential value. Fair. There's also another actual case where the DC Circuit Court of Appeals, that's one of the 13 federal circuit courts of appeals, 1, 2, 3, 4, 5, 6, 9, 10, 11, 12, plus the DC Circuit, okay? The DC Circuit Court, in another case called Heller, not that case, different Heller, this is kind of Heller 2, from several years after the 2008 landmark decision that, among other things, codified the Second Amendment as an individual right. Heller 2 at the time estimated that there are approximately 1.6 million AR-15s that have been manufactured since 1986 as of 2011. I'd call that just a bit of an underestimate, but just the same, based on that, they said that, look, accordingly, the court finds that, in essence, AR-15s based on 1.6 million, common use. So the court wraps up, now we're back to the Fifth Circuit, saying that accordingly, the court finds that braced pistols regulated under the final rule are commonly used by law-abiding citizens for lawful purposes. From this case, quote, the braced pistols subject to enforcement of the final rule are in common use today, and possession and use of braced pistols is therefore within the ambit of the Second Amendment protection. Now, again, for you Seventh Circuit enthusiasts who have never heard of the common use test, because instead you prefer what they just came out with in the last week, this contrived military versus civilian use test, let me help you out. To find the common use test, you're going to New York Rifle State Pistol Association v. Brune. I want you to flip to page 2128. In the DC versus Heller case, I want you to flip to page 627. That's where you will find, quote, the Second Amendment protects the possession and use of weapons that are in common use at the time. Just throwing that out there. Do with it whatever you want. So then the court goes on, because if you're like a lot of people, I know the types of questions we're going to wind up seeing in the comment section. And I invite you, please participate in the comment section after this video is done going live, because those are the videos that get memorialized, or those are the comments that get memorialized for all time. And I love reading comments and responding to them. And I can already see some of those comments coming up. The comments, a couple of them are going to go something like this: why are we deciding these cases on the basis of Administrative Procedures Acts and logical outgrowth tests? Why are we deciding these cases strictly on common use? Why can't we just go to the fact of, look, the Second Amendment says shall not be infringed, and end this? Just end the kabuki theater, right? Well, the court sort of gets out in front of it here in this case, Britto versus ATF. And the court says that the Second Amendment the court invokes the constitutional avoidance doctrine to basically avoid the Second Amendment and any constitutional issues. What is that? Really quickly, if the court is asked to decide something on constitutional grounds, that particularly when it's reasonably novel, if the court has an opportunity to decide this on other grounds, it ought to do so. It ought to do that because, frankly, it's not necessarily the highest priority of a lower court to be looking at and deciding constitutional issues if it can be avoided, number one. And number two, frankly, to conserve limited judicial resources. In case this is news to you, almost every trial court in the United States is, frankly, grossly overworked and understaffed, and going through lengthy constitutional balancing tests, which I know you're going to say, Tom, that's literally their job. I get it. But this is part of the distribution, in essence, of the workload across the system of, look, leave those questions to the higher courts, the lower courts. If you have an opportunity to rule on separate grounds, go ahead and do that. And then the court got to the phrase that I started with: for the foregoing reasons, the court grants the motion and stays the rule in its entirety. What does that mean? Really quickly, if you've gotten this far, please click that like button. If you're just browsing through and happen to find us, we post all sorts of Second Amendment news. Usually we don't do breaking news. This was kind of a fun new one for me, but be sure to hit that subscribe button. Make sure you don't miss any other future content. Also, if you are a Wisconsin resident, I'm going to do a plug for a sponsor, but full disclosure, the sponsor is me. CounterpointSeminars.com. I'll be posting that in a pinned comment below. We're talking about Wisconsin's basic duty to retreat laws when it comes to self-defense. Yeah, I know that's probably news to you. Also, the potential aid that you have a duty to render to a victim, namely that person who just attacked you moments ago. December 16th, tickets are limited. Be sure to check it out. I will be a key speaker there, as well as some other fantastic criminal defense attorneys. CounterpointSeminars.com. So where does that leave us? Well, unless you can come up with an alternative meaning to the phrase, for the foregoing reasons, the court grants the motion and stays the rule in its entirety, that makes it so that the rule is, not stayed in its entirety, then it seems like to me the rule is stayed in its entirety. And I talked to one of the attorneys, Attorney Weber from the Wisconsin Institute for Law and Liberty, who indulged some of my questions before I went live. And as they posted on their Twitter, their view, this is a nationwide injunction. You do not need to be in the Fifth Circuit. You do not need to be a member of any particular group or donor to any particular organization. In their view, and I'm the messenger on this, I'm not giving you my legal pronouncement on this. I'm passing along their legal pronouncement on this. This is an immediate nationwide injunction. Period. For now. Because this will almost certainly be appealed. Let's be realistic. The good news, though, is that while there are approximately 94, give or take, federal trial district courts, this is coming out of the Northern Federal District Court of Texas, where it will be appealed to is already predetermined based on what Federal Circuit Court of Appeals that court is in, here in the Federal Northern District Court of Texas. Meaning that we're going to this circuit called the Fifth Circuit. If I'm the ATF, I am afraid of the Fifth Circuit. If I'm the ATF, I do not like the Fifth Circuit. If I'm the ATF, I'm going to lose in the Fifth Circuit. Because you see, the Fifth Circuit has been handing down so many pro Second Amendment decisions that the odds are good. If you've been following this channel for the better part of the last year, and if you saw me say something great coming out of a federal circuit court of appeals, there's probably a 90% chance that came out of the Fifth Circuit Court of Appeals, just like Mock v. Garland, which is the case that this judge was citing to. In other words, if the ATF is going to be appealing this, which of course they're going to be appealing it to the same court that already ruled against them on APA grounds. Do you think they're going to reverse themselves now? I don't think so. What does all this mean? It means we've got a nationwide injunction. That's what it means. It means that we're going to have a nationwide injunction unless there's some sort of ex machina that swings in and is just a force that I don't see out there. That's going to completely change things. It means that there's a really good chance the Supreme Court is going to be getting involved in this, much like they unfortunately did in Frames Receiver and some other things. And I suspect that while we have seen, as I did another video a couple days ago, talking about the 3 U.S. Supreme Court cases in the last week, 1 on oral arguments on Tuesday, 2 that they accepted last Friday, this issue, in my mind, really, really good chance this is going to the U.S. Supreme Court, as well as Beavis v. Naperville. That's the case coming out of the Seventh Circuit Court of Appeals, where they just dealt with the injunction issue there. That's going to be most likely what's going to wind up deciding whether or not we have a right. I'm going to reword how I say that. Whether that's going to recognize our pre-existing right to so-called assault weapons, semi-automatic modern sporting rifles, as well as so-called high-capacity magazines, i.e. normal capacity magazines. I think that's the battlefield of where I see things going to the U.S. Supreme Court, both now, where they've got 3 cases, 1 under oral arguments already done. We've got 2 more coming up next year, so 3 already on the docket. And I think 2 more that look like they're on a very strong collision course. Very strong collision course. I don't know if it's going to be Britto versus ATF. Now, it might be with this. I don't know. It's going to be maybe neck and neck with this versus Mock v. Garland. There's a lot of cases basically racing for that distinction with the pistol braces. So be sure to post up your questions after this video goes live in the YouTube comment field, not the live chat. I will do my best to read the live chat, but the YouTube comment field is where I tend to live and eat and breathe. So be sure to post up your comments and feedbacks to that. If you've not already done so, be sure to hit that like button, subscribe to make sure you don't miss any future content if you're just browsing through. I want to close with my quote of the day. This one comes from Greek philosopher Epictetus. Don't explain your philosophy, embody it. Just like we've had so many fantastic groups embodying the Second Amendment with their zealous advocacy, and that especially includes the Wisconsin Institute for Law and Liberty. So be sure to give those guys some love on Google My Business. I know they get hammered by people who don't like them there. So again, my name's Tom Grieve. Thanks for stopping by. I will see you in the comments section, and I will see you in the next one. Don't forget to check out counterpointseminars.com if you're a Wisconsin resident. Take care, guys.